In federal courtrooms across America, a legal battle is unfolding that could reshape the future of artificial intelligence and music. Major music publishers have launched billion-dollar lawsuits against AI companies, alleging the largest copyright infringement in modern history. The defendants, Anthropic, maker of Claude AI, and Suno, a music generation platform. The accusation, training their systems on copyrighted songs without permission or payment. At stake is not just money, but the very framework that will govern how AI learns, creates, and potentially disrupts entire industries. The lawsuits were filed by a coalition of the world's most powerful music publishers. According to court documents, Universal Music Group, ABKCO Music, and Concord Music Group joined forces to sue Anthropic in October 2023. Meanwhile, the Recording Industry Association of America coordinated a separate action against Suno. These publishers control vast catalogs spanning decades of popular music, from the Beatles to Taylor Swift. Their claim is straightforward: AI companies have built profitable businesses on the backs of copyrighted works, without licensing agreements or compensation to rights holders. Anthropic, founded in 2021 by former OpenAI executives, has positioned itself as a leader in AI safety. The company's flagship product, Claude, is a large language model that competes directly with ChatGPT. According to reporting from TechCrunch, Anthropic has raised billions in funding from investors including Google and Spark Capital. The company emphasizes responsible AI development. But according to the lawsuit filed in Tennessee federal court, Anthropic's training process allegedly ingested thousands of copyrighted song lyrics without authorization, allowing Claude to reproduce them on demand. Suno represents a different category of AI, generative music creation. The platform allows users to type text prompts and receive complete songs with vocals, instruments, and arrangement. According to the company's own marketing materials, Suno has generated millions of tracks since launch. The technology appears remarkably sophisticated, producing music in various genres and styles. But music publishers allege this capability was built through systematic copying of their copyrighted recordings. The lawsuit claims Suno trained its neural networks on protected songs without permission, essentially teaching the AI to mimic and recombine elements of existing music. The lawsuits paint a picture of industrial-scale copying. According to the complaint against Anthropic, the company's AI can reproduce lyrics from over 500 copyrighted songs when prompted. The filing provides specific examples. Users can ask Claude for lyrics to popular songs and receive near-perfect reproductions. For Suno, publishers claim the AI generates music that closely mimics copyrighted works in melody, harmony, and style. The allegations suggest these companies scraped massive datasets from the internet, including lyrics databases and music files, then used them to train their models without securing licenses or paying royalties. To understand the dispute, we must understand how AI systems learn. Large language models and music generators are trained on enormous datasets harvested from the internet. According to research papers from leading AI labs, these datasets can include billions of text documents, images, and audio files. The AI analyzes patterns, statistical relationships, and structures within this data. For music AI, that means learning melody patterns, chord progressions, lyrical themes, and vocal styles. The system doesn't store complete songs, but rather develops the ability to generate new content based on patterns it observed. Publishers argue this process itself constitutes copyright infringement. The lawsuits seek damages that could reach into the billions. Copyright law in the United States provides for statutory damages up to $150,000 per willfully infringed work. With hundreds or potentially thousands of works allegedly infringed, the math becomes astronomical. Beyond direct damages, publishers seek injunctions that could force AI companies to retrain their models from scratch, a process costing millions in computing resources and time. According to legal analysts quoted in Bloomberg Law, these cases represent existential threats to current AI business models. Anthropic has mounted a vigorous defense centered on the doctrine of fair use. According to court filings reviewed by The Verge, the company argues that training AI models on publicly available data constitutes transformative use protected by copyright law. The company's lawyers contend that Claude doesn't reproduce songs but rather learns language patterns that happen to include song lyrics. Anthropic points to the AI's primary functions, answering questions, writing code, analyzing text, as evidence the system serves purposes entirely different from the original copyrighted works. The company also notes it has implemented filters to prevent verbatim lyric reproduction in most cases. Suno has taken a similar defensive stance, though details of their legal strategy have been more limited in public filings. According to statements provided to music industry publications, Suno maintains that its technology creates original music rather than copying existing songs. The company argues that learning from existing music is no different from how human musicians develop their craft by studying predecessors. Suno's representatives have emphasized that their AI generates novel compositions with unique melodies and lyrics, even if trained on patterns derived from copyrighted works. The company has also suggested that overly restrictive copyright interpretation could stifle innovation in AI music technology. At the heart of these cases lies a fundamental question: does training AI on copyrighted material constitute fair use? Fair use is a legal doctrine that permits limited use of copyrighted material without permission for purposes like criticism, commentary, news reporting, teaching, and research. According to Cornell Law School, courts evaluate 4 factors: the purpose and character of the use, the nature of the copyrighted work, the amount used, and the effect on the market. AI companies argue their use is transformative and doesn't substitute for the original works. Publishers counter that commercial AI products directly compete with licensed uses of music. These music lawsuits don't exist in isolation. According to reporting from Ars Technica, visual artists filed similar suits against AI image generators like Stable Diffusion and Midjourney in 2023. Authors including John Grisham and George R.R. Martin sued OpenAI over alleged training on pirated books. Getty Images launched its own copyright action against Stability AI. While none of these cases has reached final judgment, preliminary rulings have been mixed. Some judges have allowed claims to proceed, finding plausible copyright violations. Others have dismissed certain allegations. The music cases will likely influence and be influenced by these parallel legal battles. The music industry's demands extend beyond financial compensation. According to public statements from the Recording Industry Association of America, publishers seek to establish licensing frameworks for AI training. They want recognition that using copyrighted music to train AI requires permission and payment, just as sampling, cover versions, and synchronization do. Industry representatives have called for transparency about training data sources and compensation mechanisms similar to streaming royalties. Some publishers envision a future where AI music tools still exist but operate within the existing copyright ecosystem, paying rights holders for the data that makes the technology possible. The broader AI industry is watching these cases with concern. According to analysis from technology policy groups, requiring permission for every piece of training data could fundamentally alter how AI systems are developed. The Electronic Frontier Foundation has argued that overly broad copyright interpretations could give content owners veto power over AI progress. Tech companies warn that if training on publicly available data requires licenses, only the largest corporations could afford to develop AI, stifling competition and innovation. Some researchers note that human artists also learn from existing works without paying license fees for that learning process, questioning why AI should be treated differently. These lawsuits arrive as AI music generation becomes increasingly sophisticated and accessible. According to market research cited by Music Business Worldwide, millions of users have experimented with AI music tools. Streaming platforms have begun grappling with floods of AI-generated content. Some artists have embraced the technology as a creative tool, while others view it as an existential threat to human musicianship. The lawsuits could determine whether AI music develops as an unlicensed disruptor or as a technology integrated into existing industry structures. Record labels and publishers fear being bypassed entirely if AI can generate commercially viable music without compensating rights holders. Whatever courts decide will set precedent extending far beyond music. According to intellectual property scholars interviewed by the Harvard Law Review, these cases will help define whether AI training constitutes copying under copyright law. The decisions could affect AI development across all creative domains: writing, visual art, film, software, and design. If publishers prevail completely, AI companies might need to negotiate licenses for training data or face crippling liability. If AI companies win decisively, content creators could lose control over how their works are used to train competing systems. Most legal experts expect outcomes somewhere in the middle, with courts drawing distinctions based on specific uses and circumstances. The legal battle extends beyond United States borders. According to reporting from the Financial Times, European Union regulators are developing AI-specific legislation that addresses training data rights. The UK has proposed exceptions allowing AI training on copyrighted material for non-commercial research. Japan's Copyright Office has issued guidance suggesting certain AI training may be permitted. These varying international approaches could fragment the global AI industry, with different rules in different jurisdictions. AI companies may find their products legal in some countries but banned in others. Music publishers, meanwhile, are coordinating enforcement strategies across multiple legal systems, seeking consistent protections for their catalogs worldwide. Legal analysts have outlined several possible outcomes for these lawsuits. In one scenario, publishers win substantial damages and injunctions, forcing AI companies to delete trained models and start over with licensed data only. This could significantly slow AI music development while raising costs dramatically. Alternatively, courts could side with AI companies on fair use grounds, establishing that training on publicly available data is permissible without licenses. A middle path might recognize training as requiring compensation but allowing it to proceed under compulsory licensing schemes. Settlement is also possible, with companies agreeing to future licensing terms while resolving past infringement claims for reduced payments. Intellectual property will never be the same.